My name is Claire Finkelstein, and I'm the faculty director of the Center for Ethics and the Rule of Law and a member of the faculty at the University of Pennsylvania Law School. I'm delighted to bring this program to you tonight about journalism and national security. We're particularly pleased to be able to hold this in the Constitution Center, which is such an important location and program for all that is under constitutional scrutiny these days, and First Amendment rights in particular. The Constitution Center has been a partner with us on this program and on other programs, and we're particularly pleased to be able to partner with them today. I'd like to thank Jeff Rosen in particular, who is an old friend and one of the country's leading experts on constitutional matters, and say what a pleasure it is to be able to work together and to have him moderating this important panel. I just want to start by giving a word or two about the Center for Ethics and the Rule of Law and what it is we do, and then I'm going to turn it over to Jeff for his moderating. The Center for Ethics and the Rule of Law is an organization devoted to rule of law issues in the context of national security. We find that in national security, the tension around rule of law issues arises in its most pointed form. We therefore have studied a number of ethical and rule of law issues that arise particularly in the wake of 9/11 in order to examine the difficult tension between the preservation of personal liberties and national security imperatives that have arisen across the board in a number of fields. We began by focusing particularly on ethical dilemmas that arise in the context of military technology, but we've since branched out significantly, as today's program attests. So I will turn it over to Jeff. I'd also like to say, however, just before I do that, that we have several other partners in this venture today, and I'd like to recognize Dean Michael Deli Carpini from the Annenberg School of Communications, who is here, that has partnered with us on this venture, and also the law firm of Miller and Chevalier. Please enjoy today's program. Thank you.
Thank you so much, Claire. And ladies and gentlemen, welcome to the National Constitution Center. Our members are compelled to applaud, so I hear a smattering of them, and thank you so much. And our members also know that we can't begin a program here without reciting the inspiring mantra that Congress gave us when it created the Constitution Center during the bicentennial of the Constitution. So for the uninitiates among you, here it is. Ladies and gentlemen, the National Constitution Center is the only institution in America chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. And it is so important in these polarized times to bring together the best thinkers in America from different perspectives to debate and educate Americans about this beautiful document of human freedom that unites us, the US Constitution. Claire and Searle have assembled a dream team panel tonight to discuss this crucial question of press freedom and national security in the age of President Trump. And I'm so looking forward to the conversation. I'm going to briefly introduce them to you, and then we're just going to jump right in. James Rosen is a best-selling author and former New York Times reporter. He is the Intercept Senior National Security Correspondent and serves as director of First Look Media's Press Freedom Defense Fund. Laura Hanman is partner at the Davis Wright Tremaine and co-chair of the firm's appellate practice. And she obtained the first decision in US courts refusing to enforce foreign libel judgments as inconsistent with the First Amendment. Charlie Savage is a Pulitzer Prize-winning journalist and Washington correspondent for the New York Times, author of many important books, several of which he's discussed here. And Haley Dale is Senior Fellow in Public Diplomacy Studies at the Heritage Foundation and a Media Fellow at the Hoover Institution. Ladies and gentlemen, we have on stage with us a great journalist who was at the center of a conflict involving the First Amendment and national security, and that's James Rosen. I want to start, obviously, by asking him to describe his case and what he learned from it, but on the theory that no man should have to describe the facts in his own case, I'll just briefly read from a 2015 Economist argument which summarizes the fact that James Rosen was prepared to go to jail to protect his source. In 2006, he published a book that revealed a covert American plot in which a former Russian scientist fed flawed nuclear component designs to Iran. The Justice Department investigated who leaked the classified information and identified a former CIA employee called Jeffrey Sterling. The last time prosecutors tried to make a reporter reveal a source, Judith Miller spent 85 years in jail, but Jim, 85, what did I say?
Days.
I said 85 years. They wanted to put her in jail for 85 years, but it was 85 days that felt like 85 years. Absolutely, thank you, 85 days. Unlike Judith Miller, Jim spent neither 85 days nor 85 years, but he challenged his subpoena, saying that there was an exemption from journalists being forced to testify. It seemed like he was about to become another Judith Miller, but after securing a precedent, the government had power to make reporters talk. Eric Holder decided not to compel him to talk on the grounds that no reporter who's doing his job is going to jail. That seemed to doom the case, but the jury then defied expectations and convicted Mr. Sterling. The case went on for a decade, and in May 2015, he was sentenced to 3.5 years in federal prison, and the conviction was affirmed in 2017. Jim, I'll start with the Oprah question. You know, what did it feel like to be at the center of this debate? But really, what did you learn about the Constitution and the gaps in the First Amendment protection for reporters and sources in the course of your experience?
Well, I think what I've learned, the most important thing I learned is that the law on press freedom is vague and is constantly open to interpretation. It's open to, more, I would say more, I mean, Laura maybe have some views on this too, but I think it's more open to interpretation than most aspects of federal law because there's been so little legislation in this area, so few major landmark court cases, and so little case law that as a result, you have, enormous flexibility in the courts each time there's a case to change the law. And I think that was what was going on in my case. There was, started under the Bush administration and then continued under the Obama administration. Each administration interpreted the law slightly differently, but surprisingly, there was great continuity, more continuity than there was difference between the Bush and the Obama administrations on leak investigations. And as a result, by the time my case was over, the Obama people had taken this case and turned what could have been a fairly run-of-the-mill investigation and criminal leak investigation, and turned it into a major constitutional showdown over freedom of the press. And in my case, the district judge kept siding with me and kept quashing the government subpoenas. The Obama administration kept re-subpoenaing me. And when they finally took her subpoena of me for the trial to the Court of Appeals, and in their Court of Appeals in the Fourth Circuit, they issued a brief which was really stunning in its breadth and importance. They went far beyond what they needed to do to win in my case. What they said was, the heart of their argument was that there is no such thing as a reporter's privilege in criminal law, which sounds arcane, but it's not. What it means is there is no way that a reporter can legally protect his sources. There's no way that a reporter can be not forced to testify. In other words, they were saying that a reporter is no different from any civilian who witnesses a crime, and there's no right of a reporter not to testify to protect their sources. And so they took what was a fairly, incremental legal case and turned it into a major showdown, which when they won at the Fourth Circuit, we felt compelled to take it to the Supreme Court because it was such a basic issue. And unfortunately, the Supreme Court refused to take the case, and so the Fourth Circuit ruling now stands as the rule of law as the law of the land for Maryland and Virginia, which is where the Pentagon, the CIA, and the NSA all are, where most leak investigations start. And so the rule now, as it stands now, is no reporter has the right to protect their sources under the U.S. law in the Fourth Circuit. And so that is a horrible legacy. And I think that's the legacy of Barack Obama on press freedom. And unfortunately, I think Trump will be even worse.
We'll get to that question after a round, but Charlie, Jim has just made a stark claim about the lack of existence of a constitutional protection for reporters. Can you summarize for the argument, for the audience, what the current state of the law is? The Supreme Court has spoken about this in a case called Brandenburg, which is sort of vague, as Jim said. What does Brandenburg say? What have the lower court said? And what are the arguments for and against the existence of a reporter's privilege as a constitutional matter?
The Brandenburg case, which is from the early 70s, is one of the murkiest cases the Supreme Court has left. It was a case involving a reporter, or at least I think, who had witnessed some kind of drug activity. And the question was whether that reporter could be compelled to testify about it in court. So it was not a case where the crime was leaking information for the public. It was a case where the crime was an ordinary crime that we would recognize as such. And the court said that that person could be compelled to talk about it in a 5-4 ruling, but the fifth vote suggested in a concurrence that there was a standard by which, in some cases, judges ought to be able to quash subpoenas, and that he just didn't think that standard had been met in this case. And so for the longest time, people said, even though that case looked like a 5-4 ruling that there was no reporter's privilege, it was actually a shadow 5-4 ruling that there was a reporter's privilege. And that ambiguity endured for a generation until in lower courts sort of reached different decisions. It rarely came up in the case of a national security leak investigation. There were ways where prosecutors would just try to avoid going there. But in the 21st century, in the post-9/11 environment, and that's also because there were very few leak cases that were prosecuted in American history. There was the Pentagon case, Papers case, and then there was in the 1980s a case involving Jane's Defense Weekly, and those were the only two cases in American history through the end of the 20th century in which someone was prosecuted for leaking. And then after 9/11, in the 21st century, that started to change. It started to change with the Bush administration, continued through the Obama administration, and is now continuing into the Trump administration. So you can see that it's a sort of a bipartisan thing. I've made the argument that it is, for all the sort of politics surrounding people who are outraged about this leak versus that leak, which often depends on whose ox is being gored, that there's root causes that are structural, that the rise of metadata, which has made it very, very hard to mask who has been in contact with whom, has made leak investigations viable in a way that they just never were before. It's easier, much easier now for the government to figure out, at least circumstantially, who the likely culprit is in a way that was not the case a generation ago or even 15 years ago. And so we have seen now a regular occurrence where a leak investigation leads to an FBI agent and a prosecutor who says, we have a case here, we're going to bring it, and then the Justice Department moving forward with that. And usually that has not led to the kind of showdown that Jim experienced, in part because often people are pleading guilty without a trial, and so there's not a need to present evidence because they're being threatened with 20 or 30 years in prison and offered 2 years to take a plea and go away, and they take that deal. In the case of Jim's case, however, Mr. Sterling fought, and they wanted his testimony to close the gaps between those metadata links. And that led the Obama administration to win this landmark ruling at the Fourth Circuit, which the Supreme Court didn't endorse but didn't disturb either. And he's right that It is the law of the land where national security investigative journalism takes place that clears up that ambiguity from the 70s and says, no, reporters, judges have no right to quash a subpoena to a reporter based on common law or the First Amendment. And so that's where we are now. And it's a tool the Holder Justice Department secured for the government and then chose not to use. But it's a loaded weapon lying on the table now for future administrations, including the Sessions Justice Department.
Thanks for that great and fair-minded summary, as well as for the reminder about the use of metadata and making these investigations all the more plausible. Laura and Hella, I'd love you to debate whether or not there should be a constitutional and legal privilege for reporters. Laura, can you, if you were making the argument for why the Fourth Circuit decision was wrong and why there should be a First Amendment privilege, what would it be? And can you address the objection that some courts and legislators have made that in an age when everyone with Wi-Fi is a journalist, to recognize a reporter's privilege would mean that anyone can claim an immunity from testifying?
Well, first of all, this is a curious fact that I think it's 48 states have shield laws which do protect journalists in criminal cases and civil cases. Most of them give an absolute right not to disclose confidential sources and a qualified right not to disclose non-confidential news gathering unless there's a showing that you have a compelling need for the information and you can't get it anywhere else. So this is an instance where the states are actually, I would say, more enlightened than at least the federal First Amendment regime as it's been interpreted in the federal courts. Jim referred to the fact that the Supreme Court didn't take the case. Many of us who fervently want the privilege breathed a sigh of relief because the highest court in the land has not ruled since Brandsburg really on the applicability of a federal protection. I had the pleasure in February of re-arguing the Judy Miller case, who spent 85 days in the jail, before the D.C. Circuit, before two of the judges who presided over that case as a reenactment for the D.C. Circuit Historical Society. And what the reenactment focused on was, okay, we have Brandsburg. Brandsburg basically held there was no First Amendment privilege to protect journalists in the grand jury setting, limited to the grand jury setting. And here's Judy Miller. She's got a grand jury subpoena to find out who was the source that told her that Valerie Plame was a CIA agent and that her husband had done a trip to Niger to find out about uranium. And there was a strong opinion. The DC Circuit ruled against Judy Miller, said no, she had no privilege, but there was a very strong dissent there from a current judge, Judge Tatel, that there should be a common law privilege, much like what we have in attorney-client privilege, because we recognize that the communications between attorney and client need that protection in order to be candid and free. You have psychiatrist patient privilege. You have clergy and penitent privilege. You have other privileges that society recognizes because of the public interest that it serves. And so it was thought that there should be a federal common law privilege similarly recognized for communications between sources. And I would say Brandsburg did say there is First Amendment protection for news gathering. And that was the reason for what Charlie mentioned, that this long generational view that, yes, there was a privilege that Brandsburg recognized. But the court did recognize the value and importance of news gathering and the importance of confidential sources in order to be able to find out about the Pentagon Papers, about unlawful surveillance by the government. Many of the most important stories that we've come to recognize have depended on confidential sources. And going back to Jim's ordeal, the district court judge said in the beginning she quashed it because she didn't really think the government needed Jim's testimony. And the irony is, and we have Mr. Sterling's defense counsel right there, Barry Pollack, from from Miller and Chevalier. The irony is that they didn't really need it. And that's what, they were able to get the conviction ultimately without Jim's testimony. So the judge was right all along, and why the Obama administration felt the need to make the point is something that we'll have to ask Mr. Holder and President Obama.
Well, in the absence of being able to do that right now, I'm going to ask Haley, do you believe that there should be a constitutional or statutory privilege for reporters? And if not, can you make the case against the recognition of the privilege?
Well, first of all, I just wanted to ask you mentioned all the, in the context of metadata, people being threatened with 30 years in prison, settling their cases for, much more. Who are you talking about? Who are these? If I could just ask that question, because that kind of pinged me when it came up.
Sure.
Would you mind at all going back just for a few steps and?
So you're asking who are the people who have pled guilty without a trial in Espionage Act prosecutions?
Yeah.
So in the Obama era, it started with Leibowitz, right? Mm-hmm. And then who else did we have?
It sounded like there were a lot of them.
Kim,
Stephen
Stephen Kim. Yeah. Petraeus got a deal. Cartwright got a deal. Mm-hmm. So that's 4.
But Cartwright got a pardon.
Well, he did get a pardon after he pled guilty to one offense, and in exchange for not being charged with the others.
Correct.
There were more, I think just to summarize, there were more people prosecuted for leak investigations under the Obama administration than all other previous administrations combined.
Right. So I think that, I think that is an interesting angle on this. And we, I think, often hear talk about, well, this can get a lot worse. But I think talking about law and journalism, we need to stick to what has actually happened. And that's one of the things one of the points I would kind of like to make, because that's one of the directions that I've seen journalism go into, particularly under the present administration, that there was a lot of extrapolation going on. Now, the Obama administration set the table with this ruling, the Fourth Circuit ruling, giving the government more powers than it's had before. And what can we then talk about will happen in the years to come? Well, we can't. We can think about that, but to some extent, what I've found, and I just wanted to make this point, and then I'll answer your question, that journalism has run into some trouble with credibility among many people because speculation has become such a powerful and frequent tool in the mouths of journalists, that we speculate on what's going to happen and what if this had influenced this and what if the president will do this. Well, we still need to report the facts. So, but do journalists deserve to have a special privilege in terms of communication with their sources? Journalists have worked for many, many decades in the context of an adversarial relationship with the government. And there is that tension, I think, is built into the system that has a free press that reports on a government responsible to its people. You cannot remove that tension, and whereas I certainly think it is the duty of a journalist to go where the sources, direct them if there is a real news story, I think you cannot necessarily say that that privilege in itself exists in the way that confidentiality between a patient and a doctor exists as a matter of privacy. This is not a privacy matter. It is a professional matter. And then also the question becomes, who is a journalist? Who has that privilege? In today's world with bloggers, I write a lot of blogs myself these days, so I worked for a long time as a journalist for a newspaper in Washington. Today, a lot of people engage in journalistic activity, though they may not be attached to a news organization like the New York Times. So do they then have the same privilege for engaging in a journalistic activity? I think that's something that we need to to think about as we're establishing or talking about establishing shield laws and privileges for journalists. Also in the context of metadata, if I can just have one thought on that, it used to be that you could have a confidential source without leaving an electronic trail. And that's not such a bad thing because it means that you'll have to actually meet your sources and talk to them and get a sense of them as people, not just as electronic voices.
Can I respond briefly to that?
Sure.
Just one other case that fits the pattern I should have had on the tip of my tongue was John Kiriakou, who pled guilty for a couple years in prison. The metadata problem is not just about, oh, I can just receive an email from Ed Snowden or something like that. You need to be able to meet in person with someone and size them up. You
Absolutely.
still need some kind of long-term, long-distance communication to do that. Hey, let's meet at the Starbucks next Tuesday at 2 p.m. And even those trails are enough to provide evidence of a social link between the person who wrote the story and the 1 out of 20,000 people who knew the information, who therefore is the likely culprit. It's just so hard in the modern world. That phone call still would have happened before, it's just it would have been lost in the ether. So.
And that's why even in most of these cases, the government hasn't necessarily had to subpoena the reporter. They've subpoenaed the Gmail or Microsoft, Verizon, and gotten the metadata, the evidence of this call went to this person. What's happened is the Attorney General has passed guidelines. In the wake of Watergate, actually, they began guidelines that would protect journalists. They wouldn't go seek the journalist's records or subpoena the journalist unless they had a prima facie criminal case without the journalist's records. They had tried other sources. It was narrowly tailored. They had a compelling need for the information. So the government had a sort of self-restraint, the federal government, self-restraint on going after journalists, and ultimately, most recently, it was amended to including going after journalists' emails and content that's stored with third parties like Google or Microsoft.
So this is fascinating. We've heard a great debate about the fact that courts have not recognized a reporter's privilege, that the Supreme Court is unlikely to recognize one, and we've heard the arguments for and against Congress recognizing one, but I think it's fair to say that in practice, Halle's argument that in the age of the blogosphere it's hard to define a journalist means that Congress is unlikely to recognize one.
Well, it's interesting, though. The Congress came very close to passing a federal shield law under the Obama administration. There's been a lot of support for it in recent years. In fact, Mike Pence, when he was a Republican congressman, was one of the sponsors of a federal shield law. And so it's possible. I mean, it's not likely anytime soon, but it came very close to passage like 3 or 4 years ago. And then the Obama administration, ironically, delayed the process once it was almost through, I think, the Judiciary Committee in the Senate. They delayed the process because they wanted an even bigger loophole for national security. But it has been bubbling through the Congress over the last few years.
Fascinating. Well, Jim, I was going to ask you about your 2016 piece for the Times saying if Donald Trump targets journalists, thank Obama, saying that President Obama laid the foundation for crackdowns by President Trump, because under Obama, the Justice Department spied on reporters, labeling one journalist an unindicted co-conspirator, and so forth. So I guess what I'm going to ask you, you said that it was all, Obama made things bad and it's going to get worse under President Trump. You tell us why it will get worse and what are the legal instruments that might or might not constrain President Trump as he goes after journalists.
Well, I think actually just to step one step back, I do think that this really started, what we're seeing now, it really started with the Valerie Plame case under the Bush administration. And that was a very unique situation because there were allegations against the White House, people at the White House. there was a special counsel who was appointed. And so the whole investigation of the leak investigation, which ultimately led to Scooter Libby's being, I think his guilty, he was found guilty anyway.
But he was found guilty of,
Lying to investigators.
Yeah,
not of doing it.
right. Anyway, because it was a
Papadopoulos.
Thank you.
because it was a special counsel, and Patrick Fitzgerald, who was then the U.S. Attorney in Chicago, was appointed to be special counsel. He was outside of the normal Justice Department process, and so he didn't need approval to get to subpoena reporters. He didn't need the normal process is that the Attorney General has to approve subpoenas to reporters. And he didn't need that because he had this special power. And as a result, he broke down almost single-handedly the entire informal understanding that had existed between the Washington Press Corps and the government for the last 30 years. He began to subpoena everybody. And there was this parade of famous reporters going into the federal courthouse in Washington. Most of them went along with it and testified. And they didn't fight it. Judy Miller and I think one or two other reporters is about the only people who fought. And there was this liberal belief, it was funny, most people at the time viewed the whole case in the context as a proxy for the Iraq War, not as a press freedom issue. And so they viewed it, at the time it was viewed completely differently. No one thought, well, maybe this is bad for press freedom. They thought, oh, this is good, we get Bush on Iraq. And so there was huge liberal support for Patrick Fitzgerald for going after reporters at the time. And it had this enormous unintended consequence of changing the entire nature of the understanding that existed between the press and the government. And Fitzgerald became a hero in the legal community. And ever since, I think every prosecutor at the Justice Department wants to be the next Pat Fitzgerald. And so leak investigations, they used to have a stigma. They were looked at the FBI and the DOJ as a dead end. Now this is a ticket to stardom in the Justice Department. And so I think that has, prior to anything else, I think that was really the watershed moment, even before Obama.
Sure.
I'm so sorry to
Please,
interject
not
again,
at all.
but could we just, I'd like to interject that I would consider that, also a complete miscarriage of justice, because Scooter Libby was the one who got in the sights of the special prosecutor, but Richard Armitage later on admitted openly
that case was very convoluted. It was really screwed up.
So, it was the wrong man who ended up getting punished for it.
Well, you all were noting that in many of these things, it's not the crime, but the cover-up. It's the...
Absolutely,
Yes.
That's absolutely true.
Charlie, you had a 2016 article with a similar theme, harsher security tactics, Obama left door ajar, and Donald Trump is knocking. And I must say, as a reader, your explainers about the legal complexities of the Mueller investigation and the other constitutional dramas we're having are invaluable, so thank you for educating the public. As you look ahead to what President Trump might do to make good on his very dramatic denunciation of leaks, what might that involve? Might Mueller subpoena journalists who have relevant information, and take us forward about what kind of threats to press freedom we might expect?
Well, thank you very much for the comment on those explainers. I don't, just speaking off the top of the cuff, I don't immediately see why Mueller would be subpoenaing reporters, Mueller, that is, in trying to figure out what was going on in the Russian interference in our election and or whether there was obstruction of justice. I don't see a reportorial hook there. But what may happen, so obviously there's been a deluge of leaks this year out of the government about all kinds of things the Trump administration has been up to, and significant numbers of them have centered on signals intelligence. What did surveillance show about what Trump people were up to? For example, maybe most notably, what did surveillance of the Russian ambassador show about what Michael Flynn, Trump's first national security advisor, show regarding his contacts and discussion before the inauguration of possibly easing Russian sanctions and so forth. And that led to Flynn's downfall, his ouster from the administration. Flynn may be prosecuted for lying to the FBI about those very things, and also may have contributed to the mix that led to Trump firing Comey and then the appointment of a special counsel. So that leak had huge implications for what has unfolded since, but it was also quite extraordinary. Even when we've had leaks about the existence, for example, the article that is most famous in Jim's career about the existence of a warrantless wiretapping program in the Bush years and so forth, that was programmatic leak. This thing that is arguably illegal is happening. It wasn't, we are targeting this particular person and this is what we heard on this particular day, which tells that person that their communications are under surveillance. And so I could certainly, that kind of worry about these sorts of leaks has been part of what Trump and Attorney General Sessions have been saber rattling about in saying they're going to crack down on leaks and disclosing they have 3 times the new open leak investigations as existed in 2016. And so, it takes a while for those things to fold out, but I think that's where the focus is going to be. And I would say 2 quick thoughts on that. One, jumping off of Jim's observation about how liberals were all excited about Pat Fitzgerald getting Bush over Iraq and maybe didn't understand the Pandora's box that was being opened by that. I think liberals should be a little more cautious about cheering on the notion that someone in the government with access to surveillance information can put it out there in a way that destroys Michael Flynn's career. Maybe it was worth it in this case, given just how serious all of this surrounding stuff is. But if it becomes the new normal that people with access to surveillance can use it to take out political actors, that is another Pandora's box that may not be a place that this country should go too deeply.
I would just add one point, which I think is really interesting and important, is off what Charlie was just talking about, is you look at the kind of cases that are likely to come out of the Justice Department, the leak investigations that Charlie was just talking about. Those are completely different from what Donald Trump is constantly talking about. Donald Trump constantly talks about leaks, and he's not talking about the kind of things that are actually going to lead to prosecutions. He's talking about people saying things about him.
Right.
From the White House, which are just, politics.
Palace intrigue.
Yeah, and those are not, so we have these 2 conversations going on today about leaks. One is this very public, conversation about Donald Trump saying, I don't like people talking about me, or people in the White House leaking about what I'm about to do. And then at the Justice Department and the FBI, they're looking at very different things. And so when Trump talks about, I'm really glad we're going to go after leaks, I think he's going to be actually very disappointed in the prosecutions. They're not going to be going after people telling him how much Steve Bannon is really saying about him behind his back.
So we have one, just to complete the thought, we have one new Trump-era leak case so far. That's Reality Winters, who's sort of a low-level NSA person in Georgia who sent the intercept, apparently is accused of, it seems clear she did, a report that showed that the government knew that Russian government had been probing state election systems in a variety of states and before the election last year, sort of more hard evidence of a systematic campaign to undermine that election. But she is not who Trump is even thinking about or worrying about, is Jim's point. Trump is mad that someone reported that Rex Tillerson called him a moron in a meeting. And that's not against the law, but that's what sort of sets him off.
Great. Well, so this is really interesting. And Laura, Claire Finkelstein, our host, has introduced a distinction between leakers and whistleblowers and says that they're not always the same. Start with Reality Winters. Is she a leaker or a whistleblower? And are there some leak prosecutions that might come out of the Trump administration that you believe would actually be justified, or are all leak prosecutions unjustified?
Well, I would say, apropos of what Charlie was mentioning, the surveillance that disclosed that Flynn had been in communication with, Russian officials. That obviously had important ramifications. One would argue that Flynn was perhaps compromised in some way and therefore should not be national security director. Is that important for the public to have that information? Yes. Is it, so I would say that was a leak. I don't know that it was a whistleblower leak. It might have been someone in the intelligence who was concerned that he was going to be having that role and that he was compromised. And
that the Trump White House had been warned and didn't care.
Right.
It was the story that caused him to be fired, not their knowledge of it, which they had 2 weeks earlier and didn't
Right.
act on.
Exactly. So that what's government scrutiny of the government is quintessentially, I would say, in the public interest. Now, it is the practice of organizations like the New York Times, if they get something that is very sensitive and could jeopardize national security, they go to the White House and take advice. At least they don't have to follow it, but at least they hear the concerns that are expressed. So it's not like at least responsible news organizations do take into account what could be the impact. Could this hurt national security if we published it? How important is the story? Is it worth taking the risk of possible leak investigation and other repercussions? All of that goes into the calculations. And I would say, yes, the palace intrigue folks are not likely whistleblowers, but I think when we're talking about national security, for the most part, they are very, strong, public interest-minded people who are not just out to get, their boss or something like that, but have an interest in. And that's where responsible news organizations have to decide. I mean, there's been a whole tension with WikiLeaks, for example, where they get a huge download of information. How, in some instances, they went to responsible publications who sort of sifted through it and decided what was newsworthy and publishable. But in other instances, they just posted it, and without that sort of screening. And I think we're likely to see, if there is ever the first prosecution under the Espionage Act of a journalist, depending on how you define WikiLeaks, if they're a journalism organization, they could well be the first, and that would be because they are a very mixed bag, I think everyone would say. And so it's hard to know exactly how First Amendment folks would rally, or would, serious publications rally in support of WikiLeaks. I actually did, before WikiLeaks was as famous as it is now, when they had gotten and posted some secret accounts from a Swiss bank in the Cayman Islands, and the Swiss bank came into the U.S. and asked that all that would be taken down, those information about those accounts be taken down. And WikiLeaks didn't really have a presence here, so the judge ordered that the domain name of wikileaks.org be cleared so that you couldn't find it in the U.S. Of course, you could find it on mirror sites around the world, but you couldn't find it in the U.S. And I represented a group of media amici who came in and supported, and said that WikiLeaks, that this takedown order was basically a prior restraint, and that WikiLeaks enjoyed the same protections for that as would the New York Times, which was an amicus. And the judge actually overturned his own order and put back the domain name and refused the takedown of that information. So I think apropos of your question of who's a journalist and who's entitled to assert these privileges, you're going to have not only the blogger question, but the WikiLeaks question, and sites like that.
And just a one-sentence addendum, because you had asked me about Mueller subpoenaing journalists. I think she makes a great point in bringing up WikiLeaks in the context. That's something I should have thought of saying. I don't know that he's going to subpoena Julian Assange from the Ecuadorian embassy in London, but it has to be something that's on the table about whether if there is some kind of broader set of indictments related to the Russian situation, does WikiLeaks publication of the DNC's emails fall into that ambit?
Fascinating. So Haley, you introduced the blogger question. I'll ask you the question of whether journalists should, like WikiLeaks, whether WikiLeaks is a journalist and should it be prosecuted under the Espionage Act. The Espionage Act turned 100 on June 15th. I know that because we did a podcast and I sang happy birthday to the Espionage Act. And the Espionage Act says that it's a crime to obtain information regarding national defense with intent or reason to believe the information will be used to hurt the United States or to advantage another country. As Laura said, no journalist has yet been prosecuted under the Espionage Act. Haley, should journalists be prosecuted under the Espionage Act?
Well, I think if we can I think if we were talking about WikiLeaks, which in my view at least certainly was vastly detrimental to a lot of American diplomacy, a lot of American defense-related documents. I mean, it seems to me if there was a case, then Julian Assange would probably fit it pretty well. And I just wanted also to make a distinction between leakers perhaps and whistleblowers, because he has often claimed that he was doing it in the public interest. A whistleblower is someone who, in Washington at least, leads a very perilous life. There are legal protections for whistleblowers who have a venue through members of Congress and congressional committees to expose what they feel is wrongdoing within the government. And those people I find are incredibly brave and honorable people who have taken a very hard path to bring corruption or misuse of funding or other misuses of government power through an existing legal process within the government. That is a little bit different, I think. And I wanted just to make that distinction between whistleblowers and leakers, who can also obviously be people who have the best interests of the country at heart, but also sometimes have political motives. With that, I do think you could make a case in some cases that national security is being compromised. And I'm not a lawyer, so I feel a little bit out of my depth here, depending on what the case is. And I think journalists sometimes have very, very august considerations for what they can and should publish. And I hope, even in the era of the 24-hour news cycle, that we still think very deeply about what should be put out in the public and what shouldn't. Because those pressures are getting more and more intense.
Can I make just a follow-up point about the Espionage Act? You mentioned something that triggered something in my head, which was where you mentioned the definition of the charge, which is the unauthorized release of national defense information. And the Press Freedom Fund that I'm now helping to run, we're helping to fund the defense of Reality Winner, who's been charged under the Espionage Act. And the lawyers in that case are now, what I think is going to be part of the defense, is that the government has, in many cases, overcharged with the Espionage Act because it's become very easy for them to declare almost any leak national defense information, when in fact that's a real term of art that should be very restricted to very high level and very sensitive and damaging information. And they are using it in many of these leak investigations, very broadly to include almost any classified information. And if you know anything about the government, virtually everything is classified today. And so one of the things that we're hoping to get in the Reality Winner case is some new restrictions on the use of the Espionage Act and the way in which they define what is the kind of classified information that can be considered for that kind of charge.
Would those be constitutionally based? You're saying the First Amendment requires a narrow definition of national security information?
No, the law, the way the Espionage Act was written, defines national defense information. And national defense information is supposed to be something that damages the national security of the United States if it's released. And that has been overbroadly used in a lot of these leak investigations. And because, as Charlie said, most of them settle out of court before they ever reach a plea agreement, it's not been tested very widely.
I pinned a couple of quick thoughts to that. I think one of the structural critiques you hear of the Espionage Act, which again is this World War I law that was passed long before we even had a system of classifying things as secret or top secret, is that the way it's written and the way courts have interpreted it, it does not allow someone who's prosecuted under it to submit as an affirmative defense to the jury that they should be found not guilty because it was in the public interest for this particular piece of information to come out. The courts have ruled that you can't say that to the jury when they're adjudicating guilt or innocence. You can only bring it up after you've been found guilty as a mitigating factor on what the sentence should be. And so people who are critical of you taking this law that was passed for spies in World War I and applying it as a sort of official secrets act to go after leakers, this is one of the reasons they think that it should be rewritten, that there should be some sort of pressure release valve for socially useful leaks so that people are not just hit with this gigantic sledgehammer that is, that maybe is not fine-tuned to the actual problem that is being brought to bear on. And the other thought I just wanted to throw out there is I think that I'm always sort of frustrated by the sort of leaking versus whistleblowing semantic debate because I think it, so people who are pro-leakers want to portray every leak as a whistleblowing situation, and people who are like government want to say, no one here qualifies, they're all just bad leaks. So whistleblowing to me connotes revealing information about waste, fraud, abuse, or illegality, but a large amount of leaks that are socially useful, I think, don't fall within that category. They're not about waste, fraud, abuse, or illegality, but they're still things that in a democracy which relies on self-government, which relies on an informed electorate to shape what the laws should be in these difficult dilemmas, there's things that people need to know that may not be waste, fraud, abuse, or illegality. And in fact, a lot of the highest profile leak cases or leak situations we've seen in recent years, especially I'm thinking about the surveillance leaks from Edward Snowden, for example, were not about things that were illegal. They were about things that were legal. And so when people like John Ty, who's in the audience here, would go to the Intelligence Committee and say, I don't think this is American, that the government can do this, can ingest all this data, can store it forever, can search it for these purposes, they would get nowhere through the official channels. Right. You can tell a member of Congress about it, because there was this gigantic structural problem that, in fact, the system secretly permitted this. Right. And then when it is revealed, it turns out there's no public support for it across the spectrum, and you get some measures of reform, like the Freedom Act a couple years ago that ended the bulk phone log collection program. But that was only possible because of an illegal leak to the press, to the public, rather than going through official channels, because the official channels were plugged.
I think the most amazing example of what Charlie was just talking about, because virtually every source who comes to the press, I can tell you, with something that we might call, a leak. Everyone, they started out going through official channels. And the official channels almost never work for anybody. Because imagine if you are, as Charlie said, most of the things that we want to know about are actually legal, or they're actually the policy. And so my favorite story on that is Ron Wyden, who was the senator from Oregon on the Senate Intelligence Committee. And for years he kept saying, if you only knew what I knew about US surveillance, you'd be shocked. But he was afraid to talk about it, and he was an elected senator. And then after Edward Snowden came out, he says, yeah, that's what I was talking about. And he was a senator who had the immunity to go to the Senate floor and talk about it if he wanted. But he didn't want to, because he didn't want to get kicked off the Senate Intelligence Committee.
We have a bunch of superb questions related to the topics we've been talking about, but I want to introduce one last one before we turn to them, and that is, Facebook and Google, and the fact that if we're talking about free speech in the age of Trump, most speech takes place on those platforms, which are not bound by the First Amendment, because that says Congress shall make no law. It doesn't say Mark Zuckerberg shall make no law. And yet we have alleged threats to national security, including interference in the election and the promulgation of fake news. A tough question, but Laura, I'll just start with you. Are there legal steps that could be taken to get Facebook and Google to address the problem of interference in US elections? And if not, are there technological suggestions? How should we think about this important problem?
I think it's an extremely difficult problem, and I don't think anyone has the answers yet. And the lawyer, I just was talking to a lawyer at Google, and they're struggling with it. And you could treat them like the phone service, like and regulate them, as a communications service, and say. But honestly, I don't even know what regulations you would put in. Would you say no foreign speaker can post during the election time? What would be the articulation of what would be the regulation? If you leave it sort of up to them to decide, well, this looks like it's interfering with the election, that's giving them a lot of power to censor speech, and that makes me uncomfortable. You could say, well, we should have, like we have when ads are on TV, it says, I endorse this ad paid for by so-and-so. We could insist on disclosure of who is putting the ads up, but there are so many organizations that are, have innocuous sounding names that wouldn't necessarily tell you, oh, that's Russia that's posting that ad. So I'm not sure that disclosure would work, but I guess if I had to pick anything, I would urge for transparency and disclosure as the only really viable remedy. They do obviously have mechanisms to take down offensive speech or language that, terrorism speech. Even that, I'm not quite sure how they do that in a neutral way without affecting other innocuous speech or speech that criticizes the government. Where do you draw the line? It's a very hard line to draw, and I don't think they found a solution. And I would just caution to not over-regulate, maybe have more transparency when things are posted. There is, though, a true value with anonymous speech, too. And, people wanting to donate, say, to the NRA, but they don't want people to know they're donating to the NRA or the anti-NRA. And there is often protection for anonymous speech, including, there was a case yesterday from the Ninth Circuit that grand jury subpoena to a platform called Glassdoor, where people are supposed to post concerns they have about employers. And the Ninth Circuit just said, no, you have to disclose who posted those criticisms. And they went back to the Brandsburg v. Hayes model and strictly applied that. But these are a lot of competing concerns, and I know I'm not making any sense, but because there's no good answer.
No, which makes a perfect amount of sense. That was beautifully summarized, and it's a really complex problem, and you gave it to us.
Can I tell you one thing?
Sure.
In my new gig as running this Press Freedom Fund, we get applicants from all over the world, and one of the the news organizations that need help fighting back against the governments. And we have just decided to support one news site in a country that I won't name, but they're fighting back. The government wants to basically put them out of business. And one of the things that the government is doing there is they're hiring. They've got government employees who are Facebook people who go on Facebook constantly to attack the news site. And so they're government employees who are using Facebook to flood the local market there with propaganda and hate against news organizations that are critical of the government. And as this person who was applying for this stuff from me said, we're 6 months ahead of you where you are today.
Mm-hmm. So, Charlie and Helly, any solutions to that problem, technological, legal, or otherwise?
Well, I mean, I would definitely agree that the greater degree of transparency in political advertising on any of these websites, whether it be whatever they are, it's the way to go. I mean, I think you can go back to campaign finance laws, to other media practices, and can look at the internet as another medium, not as a world by itself, but a space that ought to conform to some degree, at least, to the way that media in general is regulated or not regulated. I mean, we have precedents in the non-virtual world that I think we ought to draw on more than we do. The internet sort of burst on us like this wonderful Wild West frontier, and the way it's turned out, it was not altogether benign. I think we have to go back to what we know and draw the lessons from what we know and start applying them.
Charlie, your thoughts, and maybe you could help us in your great explainer mode. There was recently a congressional hearing with the platforms where they got a lot of heat. What were the senators pushing for, and what are the menu of options on the table?
Well, so the members of Congress are upset at Facebook and Twitter for not having done a better job of recognizing that a certain number of accounts were being operated, were not real people. They were being operated out of troll farms based in Russia and so forth, and just sort of letting them run amok. And the social media giants are defending themselves and certainly trying to evade regulation of any sort here. And I guess I just, I side with the view that this is really complicated and dangerous stuff to mess with, where there is no sort of clearly correct answer. I mean, it does seem dangerous to have the government coming in and saying, you will regulate the speech that operates on your platform in the following way. You can see how that would open the door to all kinds of things. On the other hand, do they really, even asking them to do it themselves could also be another one of these Pandora's boxes where they set up their algorithms to suppress certain things that today it's, the Russian fake account that says, is trying to stir up social discord and suppress certain types of vote turnout, but tomorrow it's just the NRA or something like that, and do we really want them to go there? So it's one of those fascinating dilemmas that we still don't really fully have our hands around about how technology is changing the very essence of how the society is going to govern itself.
Well, I think the social media platforms are making so much money. I mean, hundreds of billions of dollars. I think they have. I'm not sure that there's any regulatory answer, but I think there's a moral obligation they have to begin to put money into actual news organizations to actually create their own, start their own news organization so that they have real news, and so that is part of the antidote to all the other stuff that's coming through their sites. That they actually develop create their own news organization and then say, this is what we really believe is the real news. And I think that, to me, I'm kind of surprised that they haven't come up with a fairly simple, straightforward answer to why don't we create real content as the answer to all the crap that's going through them now.
That's an excellent constructive suggestion, and we will take it to Google and Facebook right away.
But if I just also add, I mean, in my view, they also ought to be, I mean, they have such a vast platform posting some public service announcements to their users about what, I think we all need to actually to re-educate ourselves a little bit as critical readers. A lot of people do pass news around on Facebook, and I'm sure we have all done it at one point or another if we have a Facebook account. But should we? And I think that, these things are not givens. There are discussions that can be had and should be had on those platforms.
Okay, great. We have about 15 minutes for questions, and the questions are excellent, and 3 of them concern the definition of a journalist, so I'll read them all. Why can't we just define journalist as a person who disseminates information to the public or a segment of the public? It is the revelation of the information itself that is important and the source of the information. The second question is, do states that have shield laws to protect the media and sources define media and journalism? Is there a consistency in those definitions? What's to prevent people who are not attached to journalistic organizations from claiming shield protection? And then, nice summary, how should we define journalist? Haley, you started us off with this and said it was tough to define it, but if you had to, how would you define it?
Well, I think actually the initial definition that you read there on the first card you had seemed like a pretty decent one to me. It is true that you don't have to work for a major news organization to be an excellent journalist. To me, it is somebody who acquires knowledge firsthand and disseminates it with the public good in mind, with verifiable, hopefully identifiable sources, and more than one of them. I think some people have lost a bit sight of that. So I like your initial definition there.
Laura, do the states that have shield laws define journalists, and how do they define it?
They do. In fact, I just won a case against Murray Energy on that very subject. The New York Shield Law defines journalist as a professional journalist, can be working on not necessarily for on any platform, and it's really a functionality test. Is the journalist gathering information for the purpose of disseminating it to the public, and is the acquisition of information from the sources part of that news gathering process, and does he exercise or she exercise independent judgment as to what stories they're going to investigate. And so the issue came up with Murray Energy. I represented a news organization that you would have to call a niche publication. They cover distressed debt, bankruptcy basically, and they have a newsletter. They send out emails every day, and they have, but they have subscribers, and it only goes to subscribers, and subscribers are not allowed to share the information widely, and they charge a lot of money to their subscribers. And so Murray Energy said, well, you're not a news organization. And the court agreed with us that, yes, they were a news organization because they were gathering information about Murray, in this case about the fact that they had reached a favorable renegotiation with the United Mine Workers, and that how did that affect their debt. And they published that to their subscribers, albeit only 325 institutions with 9,000 readers who had paid up to $120,000 for a subscription. But the court agreed that that was a news organization, and the journalist was entitled to protect his confidential sources.
Great. Before I ask for Jim and Charlie's definition, a quick fact question: which two states do not have a shield law?
That's a good question, and I don't know the answer to that.
Issue spotters are always tough in law school. Jim, how would you define it? Would WikiLeaks qualify as a journalist under the standard that Haley and the questioner proposed, which is someone who collects and disseminates information to the public, and what's the best definition?
Yeah, I think Haley was right. That is a pretty good definition. It's pretty close to what I would say. I think I guess I would define a journalist as someone who collects information with the primary intent of making it public to other people, rather than just to keep it for themselves for any other reason. And I think under that definition, it would be hard not to include WikiLeaks. I think WikiLeaks has, one of the issues for them, I think is interesting, is that they started out they've gone back and forth between being a source for news organizations and being a publisher. And so that's really the definitional issue that major American news organizations that have dealt with them have had with them. Is, are you our source or are you our publishing partner? And they've gone back and forth. And, but But in either event, they're probably a journalist, right? I mean, they're sharing information publicly with the intent of, stirring a debate. So I don't know.
Is there an argument, Charlie, that WikiLeaks is not a journalist, and who wouldn't be a journalist under the definition we're talking about?
So let me duck the WikiLeaks question, but I will, in the abstract, just for the benefit of the audience, I'll say, here's why it's not that simple, and in the realm of national security, the legislation keeps getting jammed up in Congress. So the worry is, the problem is that the old school of espionage is you take the information and you secretly send it to Moscow or Beijing or and they benefit from it because they know the thing, and the U.S. government doesn't know that they know the thing, or reverse it. The U.S. government is the spy, and that's the sort of the model that we think of for spying. But there is another model, which is you can damage the country, your adversary country, simply by exposing the thing, or putting it up on the web so that the public learns it, but so does Moscow or Beijing or Washington, if it's the flip side. Who put out the Panama Papers? Was that the CIA? Who knows, right? But that had all this stuff about Russian oligarchs and where their money was hidden, and didn't have any information about where American oligarchs' money was hidden. And so we saw in the Chelsea Manning trial, for example, the government floating a theory that by putting information out there on the web, because the bad guys have web connections just like the American voters, that Manning was aiding the adversary. That legal theory failed in the case of Manning, but it continues to hover around all these sort of 21st century insider threat programs that are treating spies as equivalent to leakers. Right. And the notion that information doesn't just go to the public, it goes to anyone in the internet era. And so if in a 21st century espionage operation could very well be, let's have someone running a website that will publish, let's say, all of the NSA's hacking tools, and that person can say, I'm a journalist, think the world, the public should know this, but really it is a way of laundering information out, and then the investigation says, tell us who gave this to you, and they claim the reporter shield, and they're not Jim Risen trying to get an important public policy issue out before the public. They really are just part of this conspiracy, falsely claiming it. And how do you draw the line? It's like what the old saying is about pornography versus art. You kind of know it when you see it, but that is a way of substituting for statutory code that has bright lines and black and white definitions where something is clearly excluded categorically because
as Charlie knows very well, his example of the NSA hacking tools, WikiLeaks or I forget, was it WikiLeaks or somebody else?
WikiLeaks.
Well, the shadow brokers.
Shadow brokers.
Who knows who they are?
Yeah. They released, anyway, a bunch of documents have been released from WikiLeaks and other organizations that may or may not have been sent by Russia or wanted by Russia or whatever.
Hacked by Russia.
But in the end, the New York Times put them on page 1. And many other news organizations took those documents from those sites, published them, and said, these are of public interest, and we're writing a news story about them. And so what is that? Is that journalism?
Although sometimes the New York Times, as a stand-in for the media, cheats a little bit, right? And the news article
we don't
is
publish all
the
of them.
spectacle of the leak. Hey, look at this thing that got leaked, right? Is the substance the leak, or is it the leak itself? Is the substance the news or the leak the news?
Since you and I did this together, I know exactly what happens. Is we write the first story, and then we write the second story. We write, here's these documents. Oh, isn't it terrible these documents got leaked?
And I think, and this came up in the argument I had where I recreated the Judy Miller argument. And I think the conclusion I and at least one of the judges came to is we shouldn't get hung up on how to define it in the statute. These cases are decided case by case by a judge who looks at the facts, and much like you said, you know it when you see it. And that is going to be how the definitions are formed, are on a case-by-case basis. And we're going to have to live with the fact that it's not going to necessarily have a bright line in the statute.
I think one of the the biggest issue on all this, to me, of recent vintage, is the DNC hack. Clearly, the intelligence community now believes that was a Russian intelligence operation. And yet, every major newspaper and news organization in America published those documents. And at the time, it was widely believed this may be coming from Russia, although it wasn't clear. So what do we make of that? I mean, when we take, the documents clearly had news value. What John Podesta was thinking was of great news value. So, but we knew these were stolen. So, I mean, I think that we were part of this process.
Yeah. And there were journalists, Frank Foer, many others, who said at the time, don't do it, you'll be complicit in this hack. Should there be any, aside from being very, very sorry and promising never to do it again, should there be any consequences, legal or journalistic? Charlie?
I don't think anyone's promising never to do it again.
No.
The information that exists, and if you have access to it and you think it's newsworthy, regardless of its provenance, at some point that's what journalists do. We're in the business of taking information that's out there or that we obtain and disseminating it. But it's obviously very tricky. Right? What really needs to happen is, hopefully, is that people need to protect their data better so we don't get into this predicament in the first place.
The Supreme Court has said that it can't be punished in the case called Bartnik T versus Salper, where a news organization received sort of in an envelope a tape of a illegally intercepted phone call where the two parties didn't know that they were being taped. And the news organization didn't have anything to do with the taping. They just received it and they published it. And the Supreme Court said that if it's in the public interest, if the information is in the public interest and they didn't do anything to sort of induce the illegal act, they just were a passive recipient of it, basically, that could not be punished. So I don't think publishing the hacked emails, as long as
no, I mean, we would do it. I would do it
with the
again.
hacking,
We would do it again.
can't
Here,
be
but it's interesting. I was at the New York Times when we did that. It's really a fascinating, very not well explored area of journalism ethics. For instance, one of the cases that I always think about in this is like, there's a line somewhere in there as a journalist where you shouldn't cross. And it's very difficult to see where that line is. Where is the line between how you gather information? And one of the most fascinating cases goes way back to this Cincinnati Enquirer reporter who he was investigating Chiquita Banana Company, and some insider gave him the passwords to people's voicemails, executives' voicemails. And he wrote this big, explosive series of stories about the inside workings of Chiquita Banana Company. And when it came out that he had done it by using the password he had for their voicemails and listening to all their conversations, he got in big trouble. And so but that is slightly different from, we're getting John Podesta, somebody else is getting John Podesta's emails and we're publishing them.
But, here's where I think the line is. If John Podesta in his email was talking about the medical condition of his daughter or something like that, you wouldn't publish that. That would not be in the public interest. And, I think about the North Korean hack of Sony. And there was all sorts of hand-wringing then about which emails are public interest there, which are not. I think that's where the news judgment comes in.
Yeah.
But it's also, the stuff is already published at that point. It's not like the New York Times can stop the world from learning whether it's what Hillary said to Goldman Sachs or what John Podesta said about his daughter's medical condition. The information is already out there. And so it's a little bit too, self-flagellating also.
Although,
we shouldn't have written about the thing that was already out anyway.
But we've also had exclusive agreements with WikiLeaks over the years, or semi-exclusive agreements.
You mean for embargoed publication?
Well, I mean, on the the military, the cable stuff. So, I mean, there's been different relationships.
I think this is fascinating. I think one more question is what we have time for, and that is this one. Can the Rosen decision be extended to book authors who obtain information from their source? That is, can authors be forced to reveal their sources? Jim?
Say that again?
Can authors be forced to reveal their sources under the Rosen decision? Book
Well,
authors.
It came as something I published in my book, so yes.
The answer is yes. Good. All right. We need to stop because all Constitution Center discussions stop on time, but I have heard in this fascinating discussion how hard this balance between free speech and national security is. We've heard calls for judges to evaluate it on a case-by-case basis, balancing these complicated values, but we've also heard the difficulties of filters and gatekeepers exercising this judgment in an age when everything can be published online and immediately accessible. I think Claire is going to have the last word, but I'm going to thank you, Claire, for assembling this remarkable panel, which has given us such an instructive and illuminating discussion. So please thank the panel.
I just wanted to close, of course, by thanking Jeff and thanking the Constitution Center again, and thanking our panelists, and to say that I think has never been more important for lawyers to be in conversation with journalists and with national security experts, as tonight's discussion illustrates. I hope we can continue the conversation as this topic becomes, I think, ever more critical and complex, and I hope that all of you will join us as we do that. Thank you again.
Great discussion.
Yeah, nice to meet you.
Excellent.